New at 6, a crucial day in court in the standoff between UPMC, Highmark, and the state attorney general. And the result of what happened today could affect the health plans for tens of thousands of people. The case before the state Supreme Court must be decided by the end of next month.
Money editor John Delano has been following the case closely and joins us now with more. John.
Well, Susan and Stacy, the consent agreement that allows Highmark customers to continue to get UPMC medical services expires June 30th, and UPMC will not extend it. But the agreement also contains a provision that allows the parties to apply to the court for a, quote, modification in the agreement in the public interest. Today, lawyers for Attorney General Josh Shapiro told Supreme Court justices that the public interest requires that this consent decree be extended, at least temporarily. 7 members of the state Supreme Court heard lawyers for the Attorney General, Highmark, and UPMC argue what the Chief Justice called, quote, a narrow legal issue before us. That issue is whether a court has power to modify a consent agreement and extend the June 30th deadline in the public interest so that Highmark customers can continue to use UPMC services after that date. Quote, we're not dealing with ordinary commercial businesses, argued Bart Delano, the Attorney General's top litigator. We are here to look out for consumers and patients. But UPMC's attorney, Leon DeJulia, said the modification clause in the consent decree wasn't a license to rewrite the decree, telling the justices, quote, it's wiping out the consent decree, including the termination date. That wasn't the purpose of this agreement, unquote. Last February, the Attorney General sued UPMC, claiming the medical provider, which also has its own insurance company, is violating the state's public charities law by its actions against Highmark customers. That case is currently in Commonwealth Court. But in the meantime, Shapiro wants the consent decree deadline extended to preserve the status quo for Highmark customers. 4 justices, Max Baer, Christine Donahue, Deborah Todd, and David Wecht, who all come from this area, ask the most questions. I'm not convinced the end date of a contract is modifiable, noted Justice Baer. There seems to be no bright line on how much change is too much change, said Justice Wecht. Now, putting on my lawyer hat, don't draw any conclusions from questions or comments made by judges in court. I spoke to both sides who feel they made strong cases. It really depends on whether at least 4 of the 7 justices think modifying the consent decree's end date is allowable if in the public interest. No matter what happens, Attorney General Shapiro's lawsuit against UPMC will continue. Susan?